what it's like to have a long day of presentations, especially from lawyers. I know that at the end of the day like this, I always want to put my head on the table. So I'm going to go ahead and get started, because the sooner I get started, the sooner we get out of here, yeah? All right. So my name is Brent Bateman. I'm the State Property Rights Ombudsman. For those of you who I've worked with before, it's good to see you again. For those of you who I haven't worked with before, just to let you know, my job is to, I'm a state employee. My job is to help you stay out of court, okay? To resolve disputes, okay? You get in disputes with property owners, with neighbors over some land use problem or some property rights issue, and they call me or you call me, and I try to help get it straightened out. Okay, and we're pretty successful in doing that. I really enjoy what I do. As a matter of fact, I'm kind of a geek about land use law. This kind of stuff that we've been talking about here all day. I mean, can you imagine someone who really loves that stuff? It's me. So, you know, it's I kind of feel sorry for me sometimes, but that's okay. So what I'm here to talk about is, simplifying land use processes. I'm going to try to give you some advice and some things that I've seen to make things simple, but before I do, I'm going to cheat a little bit with a couple of things. First of all of my land use attorney colleagues are gone, okay, which is good. I was hoping that would be the case, because after a long day of these kinds of discussions, a lot of times there's still some leftover questions, okay, and my job is to answer questions, okay. So, if anything comes up in your mind that someone discussed earlier today that you want to ask about or you want to talk about or get my take on, let's talk about it. I'm happy to do that, okay? That's what I do for a living, and I'm happy to do it today, okay? So if anything comes up, let me know. They're gone, so they won't know, or they won't ever find out that we're all like, I think that Neil Lindbergh was full of poop, or whatever, you know. Whatever you decide, we can have that discussion. Secondly, I have a question, and that's this. Is there anybody here from first or second class counties? Is everybody? What county are you from? Weaver. Weaver?
Davis.
Oh, Davis. Everybody else third, fourth, fifth, sixth, fifth class? That's good. The reason why I asked that question is because I have a presentation tomorrow. I've noticed as I've gone around, and I've attended a lot of these kinds of trainings, and I've gone to different areas to do trainings and stuff like that. I've noticed that 90% of what people receive in land use training is useless to rural areas. Okay? I mean, we could have all sorts of discussions about things that most rural areas, you get your counties of the fifth class or whatever, but you'll just never see. Okay? Yet, you guys have some issues that the people in the big cities never see, and all of us attorneys who do these things are from the big city, right? And so we just don't know what those issues are, okay? So that's one of the reasons I lobbied hard for a session that I'm going to do tomorrow about rural issues. I want to try to get to and touch some of the things that I've seen happen in rural areas, okay? But what I'm going to do is, again, cheat a little bit, and I'm going to ask you to think about and maybe help me know what some of those issues are, okay? I work in Salt Lake City. I travel a lot to rural areas, and I talk to a lot of rural people on the phone, and I know that they have their own land use issues. I've prepared to talk about some of those, but if there are some others, you know, just please raise your hand and let me know. Talk to me after and let me know. Whatever you got to do, because I want to be able to have the discussions about the things that people in rural areas are actually dealing with in real life. Okay? Does that make sense? Okay, so please let me know. Okay. Simplifying land use processes. And yes, by the way, I do take questions. As a matter of fact, I figure that having a discussion rather than a lecture is the only way we're going to get through this at the end of the day. And that is what did I
that's just by your thumb, so it'll show up if you hit it.
And nobody minds if I wander around, right? Does anybody care if I stand in the microphone? Okay. I usually don't have a problem. These are the things, some of the suggestions that I've come up with for simplifying land use processes. Again, by the way, if there's some things that you've done to simplify land use processes, let's talk about them. Because it's great to share ideas. You know, if you've done something in your county or whatever that has really worked out, it's great to let the rest of the room know. But we want to simplify what we do. Why? Because the simpler it is, the less you have to worry about screwing it up. And when you don't screw it up, you don't get, you know, huge nasty judgments against you. Okay? Again, we're trying to prevent lawsuits. Okay? So these are some of the things I thought that we talked about. Again, if you guys want to go in a different direction, say so. I don't mind. It's kind of good to go that direction. First, I want to talk about the right decision in the right place. Actually, let's go back. And I'd like to go back, I said. Stay? Okay. Keep in mind, if there's any of these, by the way, that you're particularly interested in, go ahead and sleep until we get there. Does anybody know where that picture was taken? Was it taken in any of your buildings? Does it look familiar to any of you? That was taken somewhere in Utah, not by me?
Plain City.
You think that's Plain City?
Yeah.
Who that could be, do you know why?
It is.
Is it? And do you know these people? It looks like one of those fun meetings where they're having a great discussion. But that would make sense, Plain City, that's
They're
good.
talking about chickens, I guarantee it. There was a rooster and chicken.
I probably shouldn't bother trying to talk about chickens at the rural thing. That's an urban
Nothing
problem.
against it, I'm just saying.
Chickens bite.
The first thing I want to talk about is something that has been talked about some today already. For simplifying land use processes, and I think this is the easiest way, yet every time I talk about this, like folks want to run me out of town on a rail, okay? But you need to send the right decision to the right place, okay? Does anybody need like a little review of the difference between a legislative and administrative decision? Are we all really comfortable on that? Did somebody talk about that earlier today, or we're totally pro? We already covered that? Good. Okay. Legislative decision always goes to the legislative body. Who's the legislative body? Always. The county commission. They're the only ones who can make a legislative decision, okay? But we're talking about administrative decision. What happens far too often is every administrative decision ends up in the hands of the planning commission. Now, if you're a planning commissioner, you probably enjoy that, except for one thing. It's a time sucker. You know? You don't need to do those things. Okay? The law doesn't require the planning commission to do those things. And most of them, you know, are not things that the planning commission, you know, even cares about. The planning commission is supposed to plan. Did the guy earlier today talk about that? The job of the planning commission? The planning commission is supposed to plan, okay? And if you're doing it right, the planning commission is going to be full-time, well, maybe not full-time, but highly, highly occupied with planning, okay? And one of the problems that we have, and that I see all the time, is people call me and they say, oh, you know what? We have this way outdated ordinance that we should have fixed years and years ago, and no one will give it any attention. And I say, well, why didn't the planning commission take a look at it? They're too busy doing other things, okay? That's the job of the planning commission, to take a look at those ordinances and make those ordinances work for your community, okay? To change them, to update them, whatever, okay? That's planning commission, is to plan, okay? The decisions that often get made by the planning commission often don't need to be made there. And that's my first argument to you for simplifying. Okay? Now, it used to be, and you may have heard me say this before if you've ever heard me speak, I used to go around and I used to tell people that the planning commission should never make an administrative decision. That all administrative decisions should be made by staff. And that was unpopular. I had a tomato thrown at me once for saying that. And I've actually backed off of that position. Okay? What I'm going to suggest to you is you can really simplify things in your county by directing the right questions to the planning commission and all other questions to staff. Okay? Like, the best example is a conditional use permit. Okay? Too many places the planning commission hears every conditional use permit. Well, most places, most conditional use applications are very routine and repetitive. Okay? They're the same thing every time. We know exactly what we want to do. The Ordinance spells it out, okay? There's no reason why staff shouldn't be able to make that decision. However, some conditional use permits are controversial. They can get ugly. You may want to have a public hearing, okay? My position now is it's okay to have the planning commission look at those, okay? There's nothing against it in the law, okay? And, you know, sometimes, you know, that's the best way to handle it politically, to do that. Anybody disagree with me? What I see some folks who are like, staff going, oh, that's a great idea. And some folks who are like planning commissioners go, what are you, nuts? That basically what's happening. Yeah.
Are you saying that the ones that can just be streamlined, let staff do, and then the tricky ones go to the planning commission?
That's exactly what I'm saying.
Okay, it's not an all or nothing though? I mean, is that fair to do?
You can do that.
Okay.
Okay, you can do that under the law. The law lets you say whoever you want is the land use authority for a particular decision. Okay, so you can say for these decisions, these kind of conditional uses, those go to staff. Okay, staff knows what to do with those. We've seen them a million times. Those go to staff, and the planning commission is free to plan. Okay, but you can say this is a particular thing. If it has these characteristics, then that goes to the planning commission, so the planning commission can have an open hearing, so people can come and feel like they've been heard. Okay? Now, there's still some dangers in that plan that your insurance carriers are going to be very wary about. So hackles are starting to raise a little bit. The main danger is the dreaded public clamor. Remember the dreaded public clamor? Okay? Cannot use public clamor as evidence to make a decision, okay? And when you have open hearings, when you have public hearings to make these decisions and people come in and line up, you got 500 people, all shouting in the microphone for 2 minutes apiece. The danger of making an argument that you made the decision based on public clamor becomes very high, okay? And if that happens, you know, you're exposing yourself to certain things. That's one of the reasons I used to argue that the planning commission shouldn't touch conditional use permits, okay? Like I said, I backed off of that, but I'm just cautioning care. All right? Yeah.
We have that happen a few different times, both at planning commission and county commission level.
Public clamor problems?
Yeah, and basically we had to tell the planning commission and one of the county commissioners that if you're going to listen to this, or you're going to change your decision, if you're going to table it, whatever you're going to do, you need to say that it's because you want to take into account, you want to think about the facts, or determine what is fact, and not just base it off what we've heard this evening.
That's exactly right. You remember that an administrative decision, okay, what the standard is for administrative decision? Substantial evidence on the record. Remember, your conditional use permit decision will be upheld if there's substantial evidence on the record. That means that if the planning commission is going to hold a public hearing, they need to be able to sort out what's evidence from what's not evidence. Okay? What is not evidence? Opinions are never evidence. They're not evidence of anything. Okay? Getting up there and saying, this will be harmful to the children in our community. That's not evidence of anything, okay? And if that's what your decision is based on, your decision is illegal, okay? Now, if it just so happens you're holding a public hearing and someone comes in and actually offers evidence, then you can consider that. But it's got to be evidence, okay? So, anyway, we're talking about simplifying, okay? It's an easy way to simplify, yeah.
What if the county staff to review conditional uses is limited to one in that county that makes up the staff? What's your thoughts on that?
Do it. Have that staff person do it, as long as they're not an idiot. Okay? If if the county council says, who are we going to have do these things, and they say, well, let's have the secretary at the desk make this decision, then your staff person probably ought to go, I think I need some little more training. But what I'm talking about is somebody comes in with a conditional use permit that you get all the time. You know, that person ought to know what to do with that if they have any kind of sense. And here's the thing, okay? I hope that most of your staff people are staff people for a reason. You know, in other words, they've been to school, or they have experience, or they're educated or something. That you're not just hiring your Uncle Billy who, you know, needs a job as staff, as your zoning administrator or whatever. Okay? If they have that education, they have that experience, and they've been around for a while, and they know what's going on in your county, and they know how these decisions are going to go, who better to have make that decision than a professional? Okay? Than someone who's going to really understand it. Okay? Again, not to say that it's not absolutely appropriate for the planning commission to make some of these decisions, but, and planning commissions, I know some of you from planning commissions, so please understand that I'm not trying to offend, because you folks you're my heroes, you folks who handle these things on a local level. I mean, that's where the real rubber hits the road, okay? But planning commissions don't like to give up power, okay? And they like to be able to they like to be able to regulate, okay? That's not their job. Planning commissioners regulate when they plan. Okay? When they go through and they say, this is what we want in our community, and they take that to the city council, or the county council, okay? And when you do that, I mean, that's a much harder job. That's a much harder job, and it's a difficult thing for planning commission to do. It takes time. Anyway, that's why the state statutes don't require that planning commissions hear conditional use permits anymore, because we're just trying to make things easier. We can make things easier, keep things sort of in the right directions, and you hear the right things, and you steer the right things away. You're going to prevent problems. You're going to prevent problems. Any other questions or comments about that? No tomatoes? All right, you can throw tomatoes at me later. It's okay. It's happened before. Oh, this is my little sheet about administrative decisions, unless you want to. I'll leave that up while we talk about this question.
Can we go back to the next one real quick? In our county, the conditional use of planning commission is only a recommended body to the county commission to make the final decision.
Really?
Yeah. So that's not required.
Please tell us that's wrong.
So even if the planning commission said, okay, guys, we don't want to hear conditional use on sidewalks or whatever, we'd have to get the same agreement from the county commissioners, because they are still the ultimate decision makers in our conditional use this time.
That's not illegal.
We share the agree.
In my opinion, it's very, very unwise. It's very unwise. Because what you've done, what your county council has done is they've appointed themselves as the land use authority for administrative decisions. Okay? First of all, talk about, I've been talking about how the planning commission has enough to do. Okay? The county commission has enough to do. I mean, and they have to deal with things that are way outside of land use. Land use is so complicated that the law requires you to have a separate body to work just on that, to work just on the land use issues. And that's the planning commission. Okay? But the county council, they handle all sorts of other things. Okay? Now, the county commission, they don't like to give up power either, so best of luck to you. But I think it's very unwise. First of all, because it's a waste of time. Second of all, because you're even further blurring the difference between legislative and administrative decisions. Okay? When the county council is making the decisions, it is so crucial that every decision that gets made in your county, that the person making it knows what kind of decision it is. Before that decision is made, that thought should always happen every time a decision is made. Is this a legislative decision or administrative decision or quasi-judicial or whatever else? That is so crucial, okay? And in my experience in situations like yours, that's not happening. And it gets mixed in ways that just causes all sorts of trouble and confusion. In addition to which, another reason why it's unwise is because the county commission has, they have other rules they have to follow. All it's going to do is complicate the whole decision-making process. I don't want to take time to get into those, but But the bottom line is, I think it's not illegal, because they can appoint anybody they want to be the land use authority. They can appoint me to be the land use authority. Please don't. But you could, okay? But, and so they've appointed themselves. That's not illegal. I just don't think it's wise. And I don't think it's a good idea. So if you're a planning commission in that county, you know, do your best to recommend and change on that, is my advice. All right, anything else? All right, let's move on. Here's what I'm seeing in my office. I have an interesting job, because I get calls from all over the state. I get calls from property owners, developers, mayors, council persons, planning commissioners, and they call and they present problems to me, okay? And since I receive calls from all over the state, from all kinds of people, I can kind of zoom in on what's going on, okay? And here's what's happening right now, from my analysis. Here's what's happening in the state of Utah right now. Building is back, okay? We had quite a lull there, quite a depression, okay? And it's starting to speed up, and it's starting to speed up very, very, very quickly, okay? We are starting to get a ton of calls from developers, okay? And what's happening, and I don't know if you've seen this in your county, but you've seen it here, if it's different, but what's happening is that projects that were midway through the completion phase are being restarted, okay? So what you had is you had all of this crazy stuff going on before 2007 when the real estate market crashed. Lots of development that was more fast, and furious, right? And then everything stopped, okay? And so a lot of projects were like some point in the process and ended, okay? And sat. And they sat for 5 or 6 years, okay? And now people are saying, let's go. Let's restart those, okay? That presents a whole new world of problems. The fact that they've sat, okay? In that 5 or 6 years, we have a new mayor, and a new council, and a new planner, and we have a development agreement that Neil talked about, that I have some comments about too, that was passed 10 years ago, that people want. Some people want that to still be effective, and some people don't. And it's causing all sorts of problems, because in that time, other things have happened in town. At that time, you know, 10 years ago, we were proving this, we had this going on here, we thought it looked good, okay? But in the 10 years it's happened, a lot of things different have gone down, so maybe this isn't the right thing for that place anymore, okay? Presents a whole new world of problems. And so what we're getting a lot of calls about is we're getting calls about what I call lot processes, okay? Like subdivisions, like revising plats, amending plats, like meets and bounds lots that were just created by meets and bounds subdivisions, like small subdivision issues, like agricultural subdivisions, things like that. Getting a lot of those kinds of issues coming across my camp. And I'll tell you what, the state statute on those things they're a nightmare. They are far from clear, in my opinion. Okay. So, my suggestion for simplifying is to have your planning commission take some time and decide exactly how you want to handle those kinds of things. Okay? I'm talking about a small subdivision, for example. Okay? There's 2 kinds of small subdivisions. Okay? Actually, there's 3. Okay? There's just a small subdivision of less than 10 lots that you can do without a plat. That has a certain number of rules. There's an agricultural subdivision where you're saying that it's agriculture now, we're going to keep using it agricultural later. That has its own rules. There's the single lot subdivision where you have 100 acres and you want to carve off a little part for give to your grandson or whatever, to keep the rest of the big things. Okay. There's all those kinds of things. Okay. How are you going to handle that when somebody comes to you? Do your statutes, do your ordinances cover those things? Do you know do you have a process in place for handling that? Because the state statutes are not that helpful. Okay? Because this is the kind of stuff that's happening to us all the time. There's a law that was passed this year about boundary exchanges. Did you hear about that? What the law says now this year is if 2 people who are joining want to modify their mutual boundary in any way, All they have to do is sign quitclaim deeds to each other and record them. That's it, and their boundary gets modified, and that's the end. And the new statute that was passed specifically says that the local jurisdiction does not have any approval of that. They get to just do it. So, I want to change my boundary, it goes like this, and I want it to go like this, and all over the big curve like that. All I gotta do is sign a quitclaim deed. And there's nothing that the county can do. And there's no approval process involved.
Are you saying in a subdivision, outside of a subdivision, or anything?
Ever.
On anywhere?
I think that's
I
how
thought it was
subdivision.
outside
It's gotta
subdivision.
be outside subdivision.
Yeah, I thought it was
Well,
outside.
okay, there is the outside subdivision.
Outside the subdivision.
Provision,
plat is
okay.
recorded.
Yeah,
But look at that language, okay? That language says that, well, let me put, I don't have the language here, or else we'd read it, but that language really narrows what, you know, what is considered a subdivision, okay? And there's also the boundary change language in, I'm sorry, I'm not being very articulate. There's the boundary change language that already exists that didn't get changed elsewhere, okay? And that has provisions about whether it applies in the case of a subdivision, or whether it applies if it doesn't apply in the case of a subdivision. And I'm not gonna try to sort through that right now. The point is, though, that it's a nightmare. And if you want to simplify things, you need to look out at the stuff that's going out, you know, on the west side of your county, and say, what are people gonna come to me with this kind of stuff? What are they gonna want to do with this kind of stuff? We need to get this straightened out.
So what are you seeing as far as agricultural subdivisions? That's kind of a broad question, but, I mean, I can address more specifically what I'm seeing commonly, and I don't know if anybody else would have comments as to how they're handling it.
I would love to hear how you're handling it, because what I'm seeing is people calling from counties, calling me, and they're saying, these folks want to do this small subdivision, for this agricultural subdivision, and I have no idea how to handle this. You know, and they asked me to walk through the statute with them, and I walked through the statute, and at the end, they're still scratching their heads.
So, something that we're commonly seeing, and I don't know that it's considered an agricultural subdivision, but I get calls a lot of times from farmers or ranchers who want to sell off their property, and let's say they live in a 5-acre zone, so they want to split it up into 5 or 5.5-acre lots, so it still qualify for greenbelt.
Sure.
They can continue to farm it while it's not selling, but they would also list it to sell it. They don't want to, they're not developers, and so they don't understand the whole development process, and they don't want to go through the trouble of putting in water, sewer.
They just figure they can sell a chunk, make some money, and
Exactly. They want to,
finance
if I can sell a 5.5-acre lot to someone at some point, they can then go through the subdivision process, bring utilities to that lot,
yeah.
and make it a buildable lot. And I don't know, I've kind of read through the state code, it's like you said, it's not necessarily all that clear. It seems to me like if it still qualifies for greenbelt, then it could be considered an agricultural subdivision. But I don't understand if someone else buys it,
Right.
however it's recorded, it's not required to be recorded by plat. You could do it by deed,
Yeah,
but that deed needs to state that it's for agricultural purposes.
that's right.
So does that mean someone like any of these farmers or ranchers could split it up like that, sell it as a 5-acre farm lot, and then the next person in line turns it into a developable lot?
Yeah, but notice that what the state code says is the state code says that if in the future you change it from agricultural, you would do a zone change, you change it from agricultural, you gotta have a plat there.
Yeah,
You know what I'm saying?
and that's what I put, to me, it's basically like fixing an illegally created lot.
Right. Right. And that's important, by the way, because that's another point that comes along with this that I'm seeing a lot, is lots that were created by meets and bounds and just recorded, right?
To me, the only difference between an illegally created lot by means and bounds and recorded and an agricultural subdivision is that deed for the agricultural subdivision states that it's for agricultural purposes. That's the only difference that I can see. So I don't know if I'm wrong, if anybody else has input or. That's all I see is the only difference between an agricultural subdivision and an illegally created lot.
I think you're right. I think you're right.
So it's basically allowing someone to legally create an illegal lot.
Yeah. First of all, let me say that it's my opinion that you have a right to have a process in place to have lots legally recognized. In other words, if someone's legally creating lots, okay, you can require them to go through a process to make that lot legitimate.
And I guess I'm okay, I guess I'm just trying to work through this in my head. I'm okay with them creating these agricultural subdivisions,
Right.
because at least when someone comes in, get a building permit or whatever, or when someone goes to buy that lot in the first place, if they do their due diligence, they'll see a recorded document that states that it's specifically created for agriculture.
Right.
Not that it's just an illegally created one, there's nothing there showing, you know. And so, at least if that's the scenario, and someone comes in with a building permit and drops it on my desk, when I go look at it, I can say, oh, this is an ag lot.
Yeah,
We're gonna have to go through this subdivision process.
this process to make it buildable.
Are you pulling a title report with every building permit application, so you can flag that, or how are you?
I usually just call the recorder's office, but
See, we're doing the same thing with the subdivision, the ag division goes, there's basically a restricted covenant against the ag division, and then the buildable lot becomes a buildable subdivision lot. That way we try and do the same thing, see if we can flag it, but, I mean, we don't call it the recorder's office with every single one, we do try and get as much information.
and most of them, I guess it just depends, you know, if it's one like this where I'm not sure, I'll call, check, but.
If it's not inside the boundaries of a subdivision, we really look close at
Yeah.
whether or not
If
it's.
someone just
exactly-
records a deed creating an agricultural lot, like you're saying, you know, and doesn't necessarily clear it to the county, when they come with a building permit, do you somehow get notified that hey, this is not a lot that we recognize as a lot?
What we recognize as a lot is a subdivided lot with a subdivided, with a recorded plat. If it doesn't have a recorded plat, we look for what vested rights might be there. If the vested right to build a home isn't there, we deny.
So basically, if someone comes with a building permit and it's a lot that you don't recognize, then you'll look it up and you'll see if if it's like an agricultural thing, and you'll say, oh, no, you can't build until we go through this process. Is that basically
Yes,
what will happen?
and it doesn't bode well in the politics, because then all of a sudden, hey, I've got the frontage, I've got the acreage, why aren't you letting me build on this? And then the council members are involved and things get weird, but that's the way we're doing it. So far, it seems to be somewhat effective.
Well, even right now, we've got one that has a home on it, and they want to do a barn or a garage. And, but, you get looking at it, and they've taken part of a county right of way. They've actually increased the size of their lot just in the last couple of years, and so.
Really? Just
Yeah.
in the documents they recorded? they've done?
Yeah, they
They just
just put
put-
themselves to
put land-
themselves,
yep.
so that was some fun too.
Well, these illustrate exactly what the point I'm trying to make here is you need a process in place to handle those. Okay? If you have an illegally created lot, and probably y'all do somewhere, okay, and someone comes with a building permit, what are you gonna do? Do you have some ordinances in place for how to make that lot into a legitimate lot? Okay, that's important, and that, talk about simplifying land use processes, you're gonna have nothing but complication if you don't have something like that when that building permit application comes.
But isn't that the point?
Well,
I hate to say it that way, but isn't that the point, to have that complication? Because had they done it legitimately through the right channels in the first place, that complication wouldn't be there.
but it's not the complication, it's the process, okay? You need a process for doing it. is what I'm-
Buy the rest of the property around you that was part of the original parent parcel and do a formal subdivision.
If that's what you want for your process. But as long as you have a
But having-
process,
okay.
then you can direct them, okay? I know a lot of places who have this kind of process in place. What they say is you have to do a subdivision application. And you and the guy who owns this other parcel have to both sign it. And so we're basically gonna rejoin this illegally subdivision line to one thing, and we're gonna relook at it. Shouldn't be a problem, you know, we really don't too much object to what you're doing here, but you have to go through that process. Yeah, and yeah, it's a you know, they shouldn't be allowed to just swing around the subdivision requirements you have in place. Okay? But a lot of places don't even have a process in place. They don't even know what to do with that.
And I think We have that process in place, we just don't have it expressly stated anywhere, and I think that probably would be wise of us to add that to our code.
Bam.
So,
That's exactly what I'm saying.
we do it, we just should make it known.
Remember, when you're adding that to your code, that's a legislative decision.
Yeah.
And legislative decisions that have tremendous amount of discretion, which means you can have just about whatever process you want. If it's in your code, then it's there, and there's gonna be no fight. There's gonna be no argument, it's there. Okay? The same goes for like non-conforming lots. You know, we have non-conforming uses and stuff like that in the state code, but there's nothing in the state code about non-conforming lots. Does anybody have a non-conforming lot ordinance that they know of? Frankie?
Like the amnesty. I think we get out of jail free.
No, what I mean is you have a lot that wasn't illegal, okay? Because there was no, say, you were allowed to build on this kind of lot 10 years ago. And
Exactly.
it looked like that 10 years ago.
Yeah.
Now you're saying, okay, in order to build on a lot, flag lots are a good example. We don't do flag
We
lots
don't do
anymore,
that anymore.
okay?
Yeah.
But it was legal at the time,
Yeah.
so can I still build,
Yeah.
right? But there is no,
Oh, but there's not a whole lot now.
right.
But it was.
So someone comes to the building permit saying, I had this lot, it was legal all this time, now I want to build, okay? Do I have a legal non-conforming lot?
Yeah.
Just like a legal non-conforming use?
Was
That's
it
the
legally
question.
platted?
Yes.
Yeah, legally platted there isn't, see? And that's what I'm saying, you ought to have an ordinance. My advice is to have an ordinance that governs that,
Yeah.
okay? Say, we will recognize legally non-conforming lots that were legally platted, but are no longer conforming under these circumstances. So that there's a process there.
What's your definition of legally platted? Are you saying a subdivision plat lot, or are you saying a recorded subdivision, or a recorded survey?
It could be any of the above. Okay, it could be a lot that was perfectly buildable just because it was shaped and formed back before there was a land use code in your county. You know, and it was perfectly legal to do then. Okay, however it was shaped and formed, just because somebody did a thing and recorded the deed.
That's up to you to decide, I guess.
That's exactly right. That's up to you to decide is how to say. In these circumstances, we're going to let this go. In those circumstances, we're not. But you try to make that clear. That's my advice. That's a question I'm getting a lot nowadays. And I just wish, and again, I talk to places that say, we don't have an ordinance to govern us to figure out how to deal with this. So I'm trying to get that message out. Any questions or comments about that? I just think that's cool. It has nothing to do with development agreements.
Well, kind of, yeah.
Did you hear that story, by the way? Yeah, they finally tore it down. This is in China or something, and the guy wouldn't move. And so, I mean, it's like a Bugs Bunny cartoon. They built a road around it. I just want to make a couple of comments about development agreements. I certainly am not going to try to revisit anything Neil said, except for kind of, he made a point in a very brief way that I think we should make it a very strong way, and that is that development agreements, in my mind, should be, you need to just be super careful about when you use a development agreement. Okay? To me, a development agreement is something that you use if you have a large, multi-phase development going on. Okay? And if I know my rural counties, that's rare. Okay? If you have a large multi-phase development going on, you should absolutely use a development agreement because that's going to simplify everything. But if we're talking about simplifying, I'm saying that for just somebody who wants to build 10 houses, somebody who just wants to put up a cabin up in the woods and everything, is, make sure your ordinances cover what you do there and don't bother with the development agreement. That's my personal opinion. The main advantage of a development agreement to me is to spell out what vests when. What developer vests in when. Most of your simple stuff, that's not going to be something, your ordinances are going to cover that. You're going to know exactly what vests when. If he makes his application, he's going to vest in this.
I've got a question for you.
Uh-huh.
So, pretend like there's a development agreement
Mhm.
for approximately 480 acres. 9 phases between the county and a developer.
You guys, did you say you were Davis County?
Nope. Morgan.
Oh,
Let's flip our badges.
I was gonna.
In Davis County. Between the county and the developer,
Uh-huh.
and the developer doesn't own all the property,
The developer doesn't what?
own all the property.
It's part of the development agreement?
No.
Do the people who do own the property, are they part of the development agreement? Then you got a real problem.
And the developer has only purchased 4 of the phases, and now they walked out of it.
The developers purchased 4 of the phases and now they want out of it, and there's a development agreement in place that covers those 4 phases, plus covers other, 5 other phases.
That are basically just the open space, no more development, no more like houses, just the golf course, nothing really that you're gonna make money on.
So what's your question?
I'd like to point out that Corby's eyes have rolled into the back of his head.
And it is
You know-
not Davis County.
Have a comment on that. Here's the thing, okay? If you're gonna do a development agreement, be super, super careful how you do it, okay? In Saratoga Springs right now, okay, they have huge, huge problems. And the reason why they have huge, huge problems is because almost the entire city was covered by a development agreement that was signed 25 years ago, okay? And it's gone through like 5 addendums, okay? And it's still not finished, okay? And the portions that are still haven't been finished are on like their 6th owner away from the person who signed the development agreement, because people went out of business and the bank took over, and then they bought from the bank and they went out of business and the bank took over again. And so now what you have is you have a person who wants to develop, believes they have certain entitlements under development agreement, parts of which no one can even find, you know, because they were so old that no one kept them, okay? And so many other things have happened in the town that if they do this there, it's just going to be like all this nice uniformity and then this big right in the middle of everything. We've learned a lot about development agreements since that has happened. There are some people with a lot of experience in development agreements since that has happened. We've had some other cases about development agreements since that has happened. The development agreement is not dead. It's just, my advice is that they should be used rarely in the right circumstances. And if they are the right circumstances, hire somebody. Hire somebody for Pete's sake. Hire an experienced professional who's done these things again and again and again. I don't care who. Except don't hire me, because I don't want that. I don't know how to, you know, what the example that you illustrated is exactly the problem that I've been talking about. You know, a development that was going, stopped, now people want to restart it, or now people want to do something else with it. They have this development agreement that's hanging on there. The development agreement is not dead. It is still the right thing to do, under the right set of circumstances. I don't know that I can say anything more than that. Yeah?
You see a lot of expiration language in development agreements. I've seen a lot of different development agreements with the agreement shall expire 15 years from signature. Are there better ways to do that at full build out, or at, you know, rather than limiting them to a specific time frame?
Here's the problem that you have is most development agreements are multi-phases, right? And so what expires when is one of the problems that you have, okay? The development agreements down in Saratoga Springs have, there's a total moving target as far as expiration goes. Because every addenda has a new expiration, you know, and so forth. I personally think that expirations on a development agreement are a great idea. As long as they are realistic. You can say that this development agreement expires at build out. You can say it however you want. But I personally think that you want a date because of the economy, because of the things that can happen. you know? Because the developer could go out of business, they could run for the hills, you know? And you want a date that says expires on that day. Are you seeing stuff like that happen in your?
Yeah, most of ours have a date. I'm just wondering about the effectiveness of that date, because we can't tell what dates the economy is going to go south, what dates it's going to come back. And then from there, you know, if a rezone was dependent on a negotiated agreement, to what effect does that zone change have? To me, that zone change stays.
What you're illustrating for me, and see, the answer to your question is, however you want that, whatever effect you want that to have, okay? I think a date is best. What the effectiveness of that date, how that date is handled, should be spelled out in the agreement. And what happens to that property if that date expires, and what happens to the zoning or whatever, should be spelled out in the agreement, okay? And what I'm saying is that illustrates my point about getting the right person to do the development. Because most attorneys even are not going to think about those things because they haven't been there. They haven't seen it. Okay? But you've seen it, get an attorney that's seen it, you get together and you're going to be able to cover it. That's right. How's that for a general, not really answering your question? Okay, I'm just going to hit a couple of quick things and then I'm just going to end. So we get out of here. Okay? Impact fees. Don't you love this picture right here? This is the giant development that started and just right at the right time. And the developer built 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, about 15 luxury homes, started another one. And it sat just like that for the last 15 years. And not one of these homes is occupied. Impact fees. Is anybody charging impact fees in the county? Okay, you want to simplify your life? Just don't. Okay, we're talking about simplifying, just don't. It's my personal opinion that impact fees do not work unless building is going heavy and steady. If development is heavy and steady, impact fees work. If development is sporadic, if development is light, impact fees do not work because they have expiration dates on when you have to spend the money and how you have to spend the money, and you probably can't get a bond and use the impact fee as security. So, if you want to talk about simplifying your life, just don't. Just don't. Any argument with that? Everyone's all like, oh, I wouldn't touch those things with a 10-foot pole. This is the last thought that came to my mind as far as simplifying, okay? Nothing is less simple than a lawsuit, okay? And nothing is even less simple than a lawsuit you're going to lose, okay? If there's a message that I want to get out, it's this. It is so important to do what you're doing today, to find out what the law is, to find out what other folks are doing, okay? And once you find that out, to follow it. The reason why is because you can't always help whether or not you're going to get sued. Okay? I mean, I know that each one of your counties, each one of you right now can think of that kooky person in the county who shows up at every meeting, right? And who you're always afraid is going to sue you. Okay? Some of you may actually have that kooky person actually on the planning commission right now.
That kooky person may be in his room.
You may be that kooky person. If it's you, they may sue you, okay? If they sue you, you want to make sure you win. How do you make sure you win? You follow the law. You follow the law, okay? We'll talk about that a little bit more tomorrow, okay? But if you get sued, or if there's a problem, if there's a dispute, there are ways to fix it without it becoming a lawsuit, okay? That's one of the reasons my office even exists, is to try to help prevent lawsuits from happening, okay? Follow the law. Know the law, okay? We have at our office a brand new website, okay? And we have put a lot of legal information on that, and we have designed it so it can be accessed on a phone or a tablet, okay? With the idea that, you know what, I want to know what the law is. I'm in planning commission meeting right now, and I want to make sure I follow the law. I want to read that statute. So you can just click on your phone, and it'll be there on our website, okay? It's a great resource. Make sure you have it. Propertyrights.utah.gov. Propertyrights.utah.gov. Property rights is one word. Take some time to make sure that you folks, Utah, UTAH. Take some time to make sure that your folks who deal with the public have the skills to deal with the public. Okay? Because people will sue just because they're mad or offended. And I can't tell you how often I get calls with people who just got treated poorly. Okay? Something I have to say to people again and again. Think about that guy. Think about that kookball in your county. Okay? And this is what I'm going to say to you. Even jerks have property rights. Okay? It's very tempting. This guy is a jerk. He was rude to me, thus he not getting nothing from me. Okay? Can't do it. That's a lawsuit, lady. Okay? Even jerks have property rights. Some of you are going, not my jerk. Okay? I will do anything I can to help you. It's my job. I love my job. Okay? So if I can do anything to help you, try to stay out of court and so forth, just let me know. Okay? Yeah.
What is the OPRO website?
That's me.
That is you?
Office of the Property Rights Ombudsman.
Okay.
There you go.
Okay, so the website here. Okay. So we'll thank you.
Okay? Any questions? Any more questions or anything? Anything to help you? All right. We'll see you tomorrow.